Hello everyone, welcome to my channel Conceptual Genetics and Breeding. In today's video, we will discuss about patents. We will discuss what are patents and what are the different requirements for granting a patent. So in our previous video, we have already discussed about the intellectual property and intellectual property rights. Means now we know what are intellectual properties, what are the rights which are given to these intellectual properties, and different type of intellectual properties we have already discussed in our previous video, that is patents, copyrights and trademarks, trade secrets and geographical indications also. So we will discuss these type of intellectual property or intellectual property rights in detail in our coming videos. So in this video we will discuss what are the patents and what are the different requirements for granting a patent. So let's start today's video. First of all, what is a patent? So patent is a right which is granted by the government to an inventor to exclude others from imitating, using or selling the invention in question for economic benefits during the specified period. So basically we can say these patents are the rights. Okay, these are the rights which are given to inventor of a particular invention. So basically if you are inventor, so you will be given certain rights just to exclude other persons from taking benefits from your invention. So for example, if you have made a new machine, so you will file a patent. So if it is found that this machine has been made by you and it is a new machine, so the patent authority, they will grant you certificate, they will grant you the rights, and those rights are known as patent. So basically the patent, it will exclude others from taking economic benefits, okay, from taking economic benefit from your invention. Okay, so you know that if you have made a machine, then it will have the market value, and in market only you can sell it. Okay, and if any company is interested in your machine, then that company will take permission from you. Okay, so you can sell your patent to them, or you can made some other agreement with them, but only you are the owner of that intellectual property of that patent. So you can decide accordingly that how can you take economic benefit from your invention. So basically we can define patent as the rights granted by the government. So these are the rights which are granted by the concerned government to the inventor to exclude others from imitating, using or selling the invention for basically for economic benefit during the specified period. So specified period means the patents, the rights, they are granted for 15 to 20 years. So during all these years you will be the owner of that patent, of that rights. So basically a patent may be regarded as a contract between the society and the inventor, wherein the inventor discloses her invention in return for the protection granted to him or her by the law or the society to control the economic benefit of that invention. So basically we can say it is a contract between the society and the inventor. So first of all, he or she, the inventor, they will disclose their invention. They will said that I have invented this machine. Okay, so they have disclosed and to the patent authority at the time of filing of patent. When you are filing an application for the patent grant, at that time you will disclose all the information regarding your invention. So in return, the patent authority, they will grant you patent, means they will grant you the protection for 15 to 20 years, so that you can take economic benefit from your invention, and other members of the society, means all other peoples, they will be excluded. Okay, means they cannot take benefit from your invention. So patent can be granted for several reasons, like it is granted for an invention including a product, means if you have made a machine or a product, like for example a new the process of making a new wine, for example, it will be an invention and you can take patent, you can file a patent for that. An innovation or improvement in an invention, means improvement in an invention means, suppose there is already a machine, but you have seen that this machine have some problem and you have modified this machine. So this is the modification in the existing machine. This is known as improvement in an invention. And a patent can be granted for the process or the product of an invention. Suppose you have made a process that by using this process, it is the first step, it is the second step, it is the third step, you can make some product. So this is the process. So patents can be granted for a process also, or the product of an invention. Like for example, we have already said a machine. Okay, you have made a machine, for that also you can take a patent. And also the process, by use the process which you have used to make that machine, the process of making a new type of wine or a new type of drink, all those are known as process patents. So a patent can also be granted for the process. And also the concept, means if you are having initial concept, that by using this concept you can make a new thing, you can have an invention. So for that concept also you can take a patent. But in this concept patent there are several things that which you have to consider. So all these are the things for which you can take a patent. So what are the different requirements for the patent? The chief requirements are, it should be novel, means novelty means it should be new. So it should be new or something new in the existing ones. Okay, so the patent, they are granted for if your product or your process is novel. Novel means new, your process is new, your machine is new, or you have made some new modification in the existing machines, then you can go for the patent. The patent should be, means it should be show the inventiveness. Okay, means some invention should be there. The patent should have industrial application and usefulness. It should have patentability and disclosure. Okay, so these are the requirements, and these requirements we will discuss one by one. First of all, novelty. Novelty means something new must be there. So the invention must be new and should not be already known to the public. Okay, so you are the first who is introducing that invention to the public. So this should be new. It is the one requirement. Second requirement is inventiveness. Inventiveness means it should represent an invention or innovation. Means something new should be made by this. Okay, it should be original, should not obvious to a person skilled in the art. Okay, means it should not a common thing, like some common things are there. It should not be common, and it should be original, and it should show innovation. Innovation means some research should be there. Industrial application and usefulness. The invention which is subjected to the patent means the invention for which you are seeking a patent. It must have an industrial application, either immediate or in the future. Means it should have an industrial application immediately, or you can say that in future it will be useful for the industry, which is useful to the society or nation also. Okay, so these are three requirements. The fourth requirement is patentability. Patentability is means that the patent which you want and which you are applying, it must be patentable under the existing laws. So there are rules and regulation laws are there, like Indian Patent Act 1970. Under these acts it should be patentable, means the thing you have invented, it should not be against the law. Okay, and this criteria vary from country to country and with time within the same country. Means for certain duration in a country, some law must be may be there, and after that some other laws may be there. So it may different in the same country from time to time. For example, in India, earlier Indian Patent Act 1970 was there, which did not allow product patent in pharmaceuticals, in food and agrochemicals, but this act was amended in India as Indian Patent Amendment Act 1999. So in 1970, the Patent Act, it did not allow patent in pharmaceuticals, in foods, in agrochemicals. But after that, changes were made in that act, and a new act was passed in 1999, which is known as Indian Patent Amendment Act. And this act allow product patents also, except for some specified medicines and drugs. So these were excluded, but the product patent, they were included in this act. Okay, so in India itself, earlier in 1970, you were not able to take the product patents, okay, in pharmaceuticals, in foods and agrochemicals especially, but in 1999 onwards you can take product patents now, except some specific medicines and drugs, which are the common general medicines. Indian Patent Act, it does not permit patenting of anything contrary to natural laws, morality, or injurious to public health. A scientific principle, an abstract theory, you cannot take the patent in the scientific principles, because these are general, and all the scientific community, all the scientists, they can use those scientific principles. So patent, they are not granted for those principles. Okay, a discovery of new property or new use of the known substance, means if you are discovering the property of a new property of elements, okay, like sodium, the new property of sodium, then it will not be patentable. A method of agriculture or horticulture, they are not patentable, and inventions related to atomic energy are not patentable. So these are certain things which you need to keep in mind when you are going to file a patent. So basically these all comes under patentability of your invention. And fifth thing is disclosure. Disclosure means an inventor is required to describe his invention in sufficient detail so that a person of normal skill is able to reproduce it. Means if a patent has been granted in the physics, for example, so a person from biology should understand the patent. It should be that simple. So basically it is disclosure of your patent in very simple language and in very much detail. For example, already known organisms may be simply named in the patent so that other persons can understand. Okay, so and if organisms are genetically modified, the nature and the method of modification has to be described fully. Okay, if you are doing some genetic modification, some gene changes are there, So you have to define the nature and method of modification, means which method you have used to modify the genes. For example, if the disclosure of an invention, if you are the benefit of this disclosure is that the disclosure of the invention gives the opportunity to other inventors to improve upon the various features of the invention, so that it can become more efficient and useful and contribute in scientific and economic progress to the of the society or nation. So basically, by disclosure, you are disclosing your patent information, your invention information, so that it will be read by the other scientists also, and they can do improvements. Okay, like for example, we have already said that, we have already discussed that the existing improvement in the existing machines, in the existing these designs, you can take patent. So it gives the opportunity to others also, so that they can improve your work, your machine, your design, and again they can file their patents. Okay, so basically this is these are the requirements for patent. What are these requirements? These are novelty, inventiveness, industrial application and usefulness, patentability, and disclosure. So in our next video, we will discuss about the procedure of filing a patent. So I hope this is clear to all of you now.